Our guest today, Scott Kimpel, is a partner of Hunton Andrews Kurth in Washington, D.C. A decade ago, he worked at the SEC on the staff of Commissioner Troy Paredes. He's one of those guys that seems to know everything. I'm Brock Romanek, today on Zippy Point. So, Scott, what's supposed to be disclosed about the role of the compensation consultant in the proxy?
This is the subject of significant attention, both in the SEC's rules, and then a lot of it gets hardwired into stock exchange listing standards themselves. But basically, companies must disclose the role of any consultant in recommending the amount or form of executive or director compensation. And if so, they must identify the name of the consultant, whether the consultant was hired by the committee or the company, the general scope of the consultant's engagement, and any material instructions the company provided to the consultant.
So what about the independence or any conflicts of interest of the consultant? How is that handled in the disclosure?
Yeah, so that's another one where the SEC wrote rules compelling the exchanges to in turn write rules. And what NYSE and NASDAQ came up with are pretty similar. The committee is required to consider the independence of the compensation consultant, giving consideration to 6 factors. Any other services provided to the company, the amount of fees and the percentage of total revenue that those fees constitute, any screens or other policies to prevent conflicts, any business or personal relationships with any committee members, whether the consultant owns any company stock, and any other business or personal relationships that may impact the engagement. And these rules apply not only to traditional compensation consulting firms, but also to outside law firms that are serving in that similar kind of capacity, which was a bit controversial at the time the rules were adopted, but hasn't really been much of an issue since. And I guess it's worth pointing out that the actual NYSE and NASDAQ listing standards don't necessarily require the consultant to be fully independent. They just require the committee to consider whether it's independent before they engaged it. As to conflicts, there's a similar kind of, it's actually the same 6 factors. And if any of those factors are present, presenting a conflict, then it becomes a disclosure issue. That's another one where folks understand the ground rules. The compensation consulting firms try not to have so many extenuating relationships with issuers that this creates a disclosure issue in the first place. Some comp committees are also gun shy about using consultants that have lots of different relationships. They want to just keep them laser focused on one thing or another. So again, in practice, I don't see this coming up a lot. Occasionally it does, but usually it doesn't.
And what if a company is hiring a consultant to provide guidance on broad-based, non-discriminatory plans?
Yeah, there's actually an exception. So item 407E3, Roman 3, does provide an exception to the disclosure requirement when the consultant's only role is to recommend the amount or form of executive or director compensation under a broad-based plan that does not discriminate in favor of the executive officers or directors. Incidentally, there's also another exception under E33 for a consultant that only provides generalized information, such as peer surveys or benchmarks that are either not customized for a given client or were otherwise prepared based on the consultant's own criteria and not in response to a tender from the company itself.
What about disclosure of the fees paid to a compensation consultant? Are those disclosed?
In certain circumstances, they are. I find the rules somewhat awkward to interpret. And the exceptions I just described apply. So if one of them is available, then there's no disclosure. Otherwise, disclosure about the consultant's aggregate fees is required when the consultant provides so-called additional services to the company. For these purposes, the SEC interprets additional services quite broadly. Anything beyond core advice related to executive officer and director compensation is considered additional services. So under the most typical scenario, disclosure is required of fees if the consultant provided additional services outside the core function, and those other fees exceeded $120,000. If those conditions are met, then the disclosure must disclose the total amount of fees, whether management was involved in the decision to engage the consultant for the non-executive compensation services, and whether the board or comp committee approved these additional services. Again, this is an area where through disclosure, I think the commission was trying to discourage certain practices. So while you do sometimes see the compensation consultant providing what amount to additional services. Again, this is an area where a lot of companies just don't want to have to make that disclosure, so they just don't do it. You know, they might hire two different consultants, one that's subject to the rules and one that might provide other services that aren't.
And then is the consultant supposed to review or consent to the disclosure before it's included in the proxy that's filed with the SEC?
There's no legal requirement to do so. The commission doesn't view the consultant's input to be the sort of expertise report where consent's required. So it's not on the same plane as an audit report or an engineer's reserve report that does require an affirmative consent. As a practical matter, though, most companies have the consultants read, reread, and reread the CD&A and provide lots of comments. So they're usually heavily involved in its preparation and its review. It's rare, I think, that you would have a consultant that provides input and then they at least not get one look at the draft.